My question for you, Marina, is what if you had to give advice, sort of points of what kind of preparation people interested in SIJ cases have to do before they come and see you? What kind of tips or advices would you give them?
That's a good question, because people do ultimately need to be prepared. There's only so much that we can do as lawyers, and there's only so much that we can do with the factual circumstances that we're given. But in terms of preparation, documents, right? Birth certificate of the child, I absolutely need it. I don't need an original, but a copy is fine. Marriage certificates. Paperwork from when that child crossed the border. Now, we have plenty of children that obtain a visa and circumstances change and they're here by visa. So I need a copy of the visa. So bring your documents to the first consul so I can look at them and see how it is that you came to the United States and what exactly are we working with. I also need an address for the other parent or both parents, because sometimes it's a cousin or an uncle or whoever it is that's petitioning for the child. I need names, addresses, and birthdays. That's the key one. A lot of times people forget, I need a birthday. I don't remember what my dad's birthday is or whoever it is, because you need to have service. So I need all of those things, essentially.
Speaking of service, do the parents who allegedly abandoned, abused, or neglected these minors, whether it's one or two, do they have to consent to the entry of this special immigrant juvenile order, or can they be simply put on notice but do not have to take an active participation in consenting for the adjudication, for this finding to be found by an adjudicating judge?
So I've done it. That's a good question. I've done it both ways. We've even tried among the practitioners that handle these kinds of matters is to have agreements between the parents, because sometimes the one parent's like, listen, I'm in X country and I can't do this, so I'll just sign it away. It doesn't work. Let me just put it that way. It doesn't work. The defendants, whoever they are, either both parents or the abandoning parent, have to be put on notice, because without notice, there's nothing you can do about it. So they have to be put on notice. Sometimes the clients say to me, I'll just give it to him and he'll sign. No, it has to be an independent third party, that I hire through my office to deliver these documents to that individual. And they have to be put on notice. Do they have to consent? No. 9 times out of 10, if this abandoning parent doesn't really care to take care of the child, they're not interested in actively participating in these cases either. So the good news is no, we don't need them to consent.
Do these immigrant juveniles, the minors, are they expected, or is it more favorable if they provide oral testimony at these family court hearings? Or in your experience, have they done that, or do you encourage them to do that?
The short answer is absolutely. Absolutely. I have to prove my case, and the only way to do that is through credible testimony. And the judge will determine whether or not the testimony given is credible or not. I find that happens a lot more with the older children. And, I have to prove my case and say whether they're in school or whatever it is that I do to prove that these children are still minors. We have to do our job. So they have to testify. Now, there are situations where I've had children that were like 3 years old. Nobody's taking testimony from a 3-year-old. I've taken testimony from a 5-year-old and from a 6-year-old, but sometimes it's real sensitive, so I try and just be sensitive in terms of children at that small age. Before I'm even able to question the child, the judge has to make a credibility decision. The judge will say, all right, you want the 6-year-old to testify, because there's certain basic things that still need to elicit. Do you live with your mommy or daddy or whoever that person is? And that child has to kind of be able to understand the difference between right and wrong, the difference between a truth and a lie. And the judge will usually play a game with the child to understand whether or not they understand what's happening. And then the child can continue and testify. So long story short, some of these children have been through just immeasurable horrors, and they don't really want to talk about it too much and to rehash it because it's emotional and it's difficult. The horrors that these children have gone through when they've crossed the border, it's just immeasurable. I can tell you many, many anecdotes about children who were held at gunpoint. I had 11-year-olds that crossed the border themselves. It took them, 3 weeks, and they pay these coyotes to take them across the border by themselves. I have an 11-year-old. You have a young child. It's immeasurable. And then they've suffered some horrors while living in their country. For example, the South American countries, the Central American countries where there's cartels and there's gangs, and it's just a horror. It's a horror, but they do. So what I do is when it's sensitive, I tell them, you don't have to tell me every single excruciating detail. I need to know what I need to know, but in the hearing, you have to tell the judge. And the judges in the surrounding counties where I practice are quite sensitive to that. Like, for example, in Bucks County, when I do them, I have the judge clear the courtroom, which is not, it's not usual. In Bucks County, he already knows that, like, for the kids that I bring in, we need to clear the courtroom.
What about the time frame? I know I'm asking you the difficult questions, especially in light of the pandemic with all of these delays, but could you give maybe our viewers some ideas or time frame of how long does a typical SIJ case take place from start to finish? I'm talking about from an intake in your office all the way to the issuance of a predicate family court.
So under the Uniform Jurisdiction Act, I cannot file this case in a court until the child has resided in that county for at least 6 months. So if it's been 3 months, we can't file. We have to wait till the child has lived here, wherever here is, for 6 months at least. 6 months and 1 day, we're good to go. So I can use that prep time if they're not here. But it also depends on whether or not they have all the documents in order. So I need the birth certificates, I need their statements, I need stories, whatever it is. Like, I'll walk them through it. Translations, exactly. So a lot of those original documents, I provide translations. I think it's easier for the court. Right. Is it mandatory? Not always, but I think it's helpful to make everything as easy as possible for the court. How long does it take? It takes me a couple of weeks. If I have all the ducks in line, we have 6 months jurisdiction, I have all the documents I need, a few weeks, and then the client and the child and the parent or whoever it is, the petitioner, reviews, make sure everything is in line, and then we submit. Every jurisdiction, their processing time is longer. In Philadelphia, for example, you go right to a judge. You skip the middleman, like the master level. So we have like several tier system in Pennsylvania for custody. It's kind of more of a straight line in Philadelphia County, and there's plenty of counties where they do that as well. In the suburban counties in Pennsylvania, there's there's a middle section, so it takes a little bit longer. So it's like 2 hearings, so it's like hops and jumps.
Yeah, and from the immigration point of view, once the predicate order is issued, in fact, the application for special immigrant juvenile status could be filed, which we call in the industry I-360. It could be filed along with the final adjudication order, and it does really depend on the case, on how long it takes for a decision from the USCIS to be issued. Most likely, we will see some kind of an answer or a request for additional evidence between 6 months to 8 months, and most cases that we have worked on with Marina get decided within about a year. A lot of our cases are of minors from South America, and unfortunately, because there's a backlog in preference categories, they have to wait 2-3 years until they're eligible to apply for permanent residency based on the approved SIJ petitions. But minors from other countries, from Central Asia, from the Russian Federation, from European countries, although less in applications, do get, in volume of applications filed, do get approved faster, and do in fact receive their green cards, their permanent residency, within approximately 24 months from start to finish. So once again, typical lawyer answer, it depends how long it takes, but the family process, as Marina has mentioned, usually will be done within 3 to 6 months. Is that a fair assessment?
Yeah, yes, it is. And sometimes we can do it sooner. So if the child is due to age out, meaning turn 18 or 21, depending on where they are, then, there's more work that I need to do to try and get them before the court sooner. So, as professionals, we work within the deadlines that we're given.
And maybe in conclusion, you could maybe comment a little bit more about that. If in fact somebody comes to your office or my office, and they're residing in Union County, New Jersey. Mm-hmm. They are 20 years old, and they are 6 months away from turning 21. So that lights a fire for us and tells us, hey, we don't have a lot of time to obtain the predicate order. How likely or how successful would you characterize your ability to, in fact, maybe obtain an emergency finding from a family court judge? Do you see that happening, and how successful are you in that practice?
So the emergency mechanism, you have to prove emergency jurisdiction. And then you have to get before the court. So it's two challenges, especially in New Jersey, for example. You mentioned Union County. I just had a case recently in Union County, but all the counties are it's a little bit more uniform in New Jersey, where it differs in Pennsylvania from county to county. But as long as you can prove, and I brief all of my cases in New Jersey, so I have to do, a memorandum of law, and there I make my case under the case law and the statutes of the state of New Jersey, where emergency jurisdiction is warranted. Like some terrible thing will happen if we can't get before the court. So whether it's overcoming the 6-month timeline, or whether it's overcoming the aging, whatever it is that we need to overcome, I have to make my case, and it's a case-by-case basis based on the facts specific of the case, how we can make that emergency happen. If somebody comes to me and they have all of these things, I have to make that determination. So I look at the facts, I look at the surroundings, I look at where we are, I look at everything, and I'll make my assessment based on my experience and what I've done in the past. Can we get it done or not? Let me put it this way: 9 times out of 10, we can get it done. Because these kids aren't coming from, a lollipop wonderful land.
Right.
They've been through measurable horrors. So there's oftentimes we have the factual circumstances to prove some sort of emergency.
And in conclusion, I would like to add that in the context of a special immigrant juvenile petition, a successful case typically involves a minor who in fact is seeking the protection of a juvenile court in the United States to have the ability to live here, go to school here, work here, and build their American dream. It does lead them to a eventual permanent resident status or a green card, which gives them a path to eventual citizenship and allows them to, in the future, petition for relatives other than their parents. So I would like to step back for a second and say that if there is a finding by a family court judge or a juvenile court judge adjudicating these minors to be, in fact, SIJ minors, they are not eligible to petition eventually for their parents because there is a finding that their parents have abandoned them, abused them, or neglected them. Now, in my experience, it rarely becomes an issue, but we do want to always warn and give that fair warning to our applicants and our clients that a path to green card and citizenship is a possibility with SIJ petition, but it is not an opportunity to, in the future, utilize the status to petition for their parents. We hope that this video has been useful to you. If you would like to learn more about special immigrant juvenile status or any status in the United States, we encourage you and ask you to please call our offices. You may reach me at voloshenlaw.com or Marina at
DivLaw PA.
We'll provide in this video links and our contact information. We thank you for viewing our videos. Please hit the like button if you would like to subscribe to our channel and to see videos like this, which will help you with your immigration status. We thank you and we look forward to seeing you soon.